we are already behind by a lot. So let's begin.
Okay.
So today is the 15th webinar of Licamr, that is LegisNation International Center for Arbitration, Mediation and Research. Today the topic is Introduction to Environmental Counterclaims. We have two of the most renowned people in this stream. That is, first is Godwin Tann, Trainee Solicitor, Allen and Overy, LLP, LLM from University of Cambridge. Second is Andrea Chong, that is Trainee Rajah and Tann, LLP, BA, University of Cambridge. Ma'am, on behalf of LegisNations and sir, we welcome you. And if we can please proceed with your introductory remarks. First, can we take Godwin answer followed by Andrea?
Yeah, sure. So hi, my name is Godwin. As Arush kindly introduced me, I am a trainee solicitor at Allen and Overy. I did an arbitration seat there, and I'm currently on a secondment in arbitration in Paris. Like Andrea, I studied law at the University of Cambridge, but I also did law at the University College London. And this presentation would be about what we do and what we've been learning about environmental counterclaims, specifically in investment treaty arbitration. I'll leave Andrea to introduce herself as well.
Thank you, Godwin. Thank you for the kind introduction. My name is Andrea, and I'm a trainee at Rajah and Tann. It's one of the big 4 firms in Singapore, and I did my training in international arbitration with a focus of arbitration mostly in Singapore. And I also spent some time in London at WilmerHale, where I also did some arbitration-related work. Yes.
Okay, thank you. So I believe that there is a presentation that is in place. Sir and ma'am, can you please proceed with the presentation? Then we'll take up some questions that we as the moderators have some questions. At last, we'll take some questions from the audience and we'll move on to the concluding remarks.
Yeah, sure, that sounds good. So the title of our presentation today is Introduction to Environmental Counterclaims, Treaties and Trajectories. The focus will be on investment treaty arbitration. We'll come into a bit more on what exactly we do, but just suffice to say for now that the views expressed in this presentation are just our own and not reflective of those of our firms or the universities with which we're affiliated. But just to begin our presentation, we'll start first by looking at what are environmental counterclaims in investment treaty arbitration specifically. Then we'll look at 2 developments. Firstly, new generation treaties, and secondly, tribunal receptiveness. These 2 developments we suggest will lead to, in the future, more environmental counterclaims arising and possibly succeeding in investment treaty arbitration. So just to pitch this at a more introductory level, what is investment treaty arbitration? It is arbitration between foreign investors and host states, so a government and an investor. And typically, those arbitrations are based on what we know as a bilateral investment treaty, or BIT. The specific type of arbitration we're looking at is conducted under the rules of the International Center for Settlement of Investment Disputes, or shortly known as ICSID disputes. And that is the kind of focus we have for today's presentation. So what is a counterclaim? If you look on the right side, you'll see a picture of a sword stuck in a stone. There is quite a famous story about this. I'm not sure if everyone's familiar with this, but I'll come to it, which is that in Arthurian legend, there is a sword, magical sword that's stuck in a stone. On the sword, there are words stating that only the rightful king can pull the sword out of the stone. So many noblemen have tried to pull the sword but failed to do so, and only King Arthur eventually managed to pull the sword and became, now we know as King Arthur. There are a few similarities between this story and the state of counterclaims in investment treaty arbitration. The first thing we note is that counterclaims function like a sword instead of a shield. By that I mean that, as the International Court of Justice has observed in the Bosnian Genocide Convention case, the thrust of a counterclaim is to widen the original subject matter of the dispute by pursuing objectives other than the mere dismissal of the applicant's claim. For example, that a finding be made against the applicant. In other words, a counterclaim seeks an affirmative relief against the claimant rather than just dismissing the claimant's claim. So in that way, it's more offensive, and in that way, it functions more as a sword. Secondly, like the Arthurian sword, counterclaims are very difficult to raise in investment treaty arbitration for the reasons that we'll come to later. But in recent times, we've finally seen one or two successful environmental counterclaims, which Andrea will talk to in a while as well. So that is our overview on what a counterclaim is. So what is an environmental counterclaim? The term environment can include a huge range of things, including air, water, land, flora, fauna, natural ecosystems, sites, human health, and safety and climate. Principles in environmental law are also always shifting and very broad. They may largely refer to things like conservation, management, prevention, sustainable development, and protection for future generations. So an environmental counterclaim refers to a counterclaim brought by a state against a claimant investor that relates to the environment. So why are environmental counterclaims important? I hope that everyone who's listening to this call would have no doubts about the urgency of the climate crisis and the difficulties that we face as a world in tackling environmental issues and risk. So environmental counterclaims are important, firstly, because we are all now aware of the urgency of the climate crisis, and we need everything that we can have to stop such environmental degradation and all the problems that come with that. And secondly, businesses too realize that and have been pivoting towards sustainable developments, and therefore it is more and more common and more likely for us to see environmental considerations in future arbitrations. Now I'll pass it on to Andrew.
Yes, thank you. Now that we understand what an environmental counterclaim is, we'll turn to consider the two key environmental counterclaim cases. These are the Burlington and Ecuador case and the Parenco and Ecuador case. I put the citation of both of these cases in the slide, should anyone want to take them down or take a screenshot for you to go and look at the full judgment later on. We can go to the next slide. So what happened in this dispute? Is the next slide, or is it lagging a bit? Yeah, thank you. What happened in this dispute is that Burlington entered into a series of production sharing contracts with Ecuador to explore and exploit certain Ecuadorian oil reserves. These are referred to the oil fields in blocks 7 and block 21 that I put in the pictures there. Parenco is a related entity and was Burlington's consortium partner and commenced the parallel exit arbitration against Ecuador as well. What happens was, after a rise in oil prices in 2002, Ecuador sought to renegotiate the prices of these PSCs with Burlington. However, it failed to do so. And so in order to get more money, it kind of introduced measures to restore what it called the economic equilibrium of these PSCs and imposed a windfall tax on any of the excess profits that Burlington made. However, Burlington naturally eventually refused to pay this tax, and Ecuador took possession of Burlington's blocks and terminated these PSCs. Could we go to the next slide? Thank you. Burlington then commenced arbitration and argued that Ecuador expropriated its investment and breached other treaty standards under the Ecuador-United States BIT. Parenco similarly commenced arbitration against Ecuador for this same reason. Now, in response, Ecuador counterclaimed against both Burlington and Parenco for breaches of Ecuadorian environmental law and for failing to maintain certain infrastructure. Ecuador alleged that Burlington's operations led to a massive environmental catastrophe in the form of significant soil and groundwater pollution in the Ecuadorian Amazon region. However, both Burlington and Parenco tried to characterize these counterclaims as an attempt by Ecuador to offset their claims. And I've actually put a quote and an extract from the decision on the counterclaims from the Burlington and Ecuador case in the slide. Here from this quote, you can see that Burlington uses quite colorful language to say that their counterclaim is fabricated or a tactical retaliation aimed at offsetting any significant damages that they were claiming. Nonetheless, both tribunals did award Ecuador its counterclaim, and it found against Burlington on a strict liability basis and found against Parenco on a partial strict liability and fault liability basis. Ecuador was awarded its environmental counterclaims, with Burlington having to pay 39.2 million and Parenco having to pay 93 million, less the 39.2 million that was awarded in the Burlington case, given that they are both related entities. While it appears that environmental counterclaims are a way for states to hold private investors responsible for some of their environmental obligations, this isn't always the most effective way to enforce environmental obligations. And in our paper that will be published later on this year, we've actually gone into these points in detail, but I'll just offer kind of an overview of the three main challenges and limitations in relying on environmental counterclaims to protect the environment. First, on the divergence in views on the scope of the parties' consent. Now, this is a bit more of an arbitration-related point. We can actually go to the next slide for this. In certain investment treaties, the scope of the parties' consent may not be sufficiently broad enough to permit a state to raise a counterclaim under Article 46 of the Exit Convention. Now, Article 46 requires that a counterclaim that is raised has to fall within the jurisdiction of the tribunal. And if it does not, parties have to actually agree that the tribunal has jurisdiction to even hear these cases. So where there's no express agreement to permit these counterclaims, exit tribunals have diverged on their approach in determining whether the counterclaims fall within this scope. We look at this in this slide, we can contrast between examples of narrow provisions and broad provisions in dispute resolution clauses. In the Rosales and Romania case, the claimant actually argued that one of the reasons why the tribunal lacked competence to hear this counterclaim was because the claimant did not consent to the counterclaims being heard. I've put the quote of the dispute resolution clause in the slide here. Now, what the tribunal found on this clause is that references to disputes concerning an obligation of the latter that undoubtedly limit jurisdictions to claims brought by investors about the obligations of the whole state. What this meant is that the issues of dispute could only be raised by the investor, and the whole state did not have a corresponding right to raise any counterclaim. As a result, the provision in the Rosales case was very narrow, and the counterclaim that was raised was not heard. In contrast, in the Abbasa and Argentina case, we have an example of a very broadly worded dispute resolution clause. Here, the tribunal found that this dispute resolution provision was drafted broadly and was completely neutral as to the identity of the claimant or the respondent in an investment dispute. This meant that both the investor or the whole state could raise any issue, and therefore the counterclaim was allowed in that case. Our second challenge to relying on counterclaims to impose environmental obligations is that most investment treaties do not impose obligations on investors. What this means is that if a state was seeking to raise a counterclaim, they would first need to find the legal basis for this counterclaim. If a treaty does not directly impose any obligations on an investor, it might be difficult to substantiate and ground the basis for this environmental counterclaim. In Burlington and Ecuador, Ecuador was able to argue that the investor owed environmental obligations on the basis of Ecuador's constitution. The tribunal was able to consider domestic environmental law because of Article 42(1) of the Exit Convention. This allows tribunals to apply domestic law. It is therefore possible that an investor may also be required to comply with international law obligations because of Article 42(1) of the Exit Convention, or because there's a provision in the treaty that requires or allows the application of international law. These are potential outstanding questions that we foresee in each case, and parties and tribunals would have to consider which aspect of domestic law is relevant, or why one could or would rely on international law or international norms to impose obligations on investors in such a situation. Our third limitation, which is not so much a legal challenge, but more of a practical issue, is that greater environmental expertise would be required in this field. We see this in the Burlington case, where the tribunal engaged in a thorough review of the expert evidence by participating in a site visit in March 2015, and even made several technical findings, such as the method that would be better suited to estimate the impacted areas and calculate volumes of contaminated soil requiring remediation. In the Parenco case, The tribunal even appointed an independent expert to review the evidence that parties had tendered. While this is a current limitation, we do foresee that as more environmental-related disputes arise, there may be more experts and more people might be familiar with such issues. However, I do think that we would have to consider the cost of proceedings in engaging many experts and the potential for a lot of documents generated as a result.
So Andrea brought us through a list of the challenges that one would face when bringing counterclaims. Now we look at two developments that suggest that in the future, it might be easier to raise counterclaims in investment treaty arbitration. The first development we look at is the rise of new generation treaties. So by 2011, 133 investment treaties expressly referred to environmental considerations in their preamble or their operative provisions. And we see provisions that directly impose environmental obligations on investors. We also see provisions that impose human rights or corporate social responsibility obligations on investors. And we think that it is arguable, at least, that those provisions can include certain environmental standards and can be used, therefore, to ground a counterclaim. An example of such a treaty, 2016 Morocco-Nigerian Bilateral Investment Treaty, Article 24.1 of this treaty states that investors and their investments should strive to make the maximum feasible contributions to the sustainable development of the host state and the local community through high levels of socially responsible practices. So this is a treaty attempting to directly impose some form of environmental related obligation on investor. We also see two other articles. Article 18.1 states that investments shall maintain an environmental management system. And Article 18.4 states that investors and investments shall not manage or operate investments in a way that circumvents international environmental obligations. So this is more of a negative obligation on an investor. An example of a human rights related provision can be found in the Southern African Development Community's Model Bilateral Investment Treaty. Article 15 states that investors and investments have a duty to respect human rights in the workplace and in the community and state in which they are located. Investors and their investments shall not undertake or cause to be undertaken acts that breach such human rights. So once again, it's a direct attempt to impose some form of obligation on the investor. And lastly, we look at a CSR provision, 2016 Iran-Slovakia Bilateral Investment Treaty. Article 10.3 states that investors and investments should apply national and internationally accepted standards of corporate governance for the sector involved. It is at least arguable, and there are some issues with this drawing such parallels, but it is at least arguable that CSR and human rights provisions can include some form of environmental standards. However, this does not mean that in the future you will see a tidal wave of counterclaims per se, because there are still certain challenges that are brought up by these treaties. Firstly, many of these treaties are silent on the issue of counterclaims. Where a treaty is silent on the issue of counterclaim, some tribunals and most tribunals will actually look at whether or not the dispute resolution provision is sufficiently broad, the issue that Andrea brought up. In other words, we still face the issue of ensuring that when you draft a treaty intending for a counterclaim to be applied, the dispute resolution provision needs to be sufficiently broad to ground such a counterclaim. The second problem we see is that many of these treaties refer to things like sustainable development or environmental protection without really specifying which aspect or what exactly they're referring to. As we've seen earlier, the definition of environment, the definition of sustainable development can be very broad. It can mean a lot of things and also nothing at all. So we do see a certain degree of uncertainty that will arise from these provisions being quite vague as to what they really are referring to. And lastly, we think that there is a potential to sidestep environmental provisions in treaties through most favored nation provisions or national treatment provisions. To give you a flavor of what we mean, if we look at Article 6.4 of the Morocco-Nigerian Bilateral Investment Treaty, it states that each party shall allow investors of the other party to make an investment and conduct business in conditions no less favorable than that accorded to investors of another third state. So in a hypothetical scenario, you could imagine an investor arguing that since I have to now adhere to certain environmental standards, since there are new environmental obligations on me, I'm treated less favorably than an investor of a third state. Therefore, through the most favored nation provision, I should be treated equally and remove the environmental obligations on me. There are certain conceptual questions that arise from such an argument. One of which we touched on in our paper is the fact that typically an investor uses a most favored nation provision to expand its protections rather than reduce its obligations. Whether or not this conceptual distinction will have a practical effect is yet to be seen, because we've not really seen it come out in cases yet, given that these treaties are still very new, but it's something that a future tribunal would have to wrestle with. The second development we see is an increase in tribunal receptiveness towards environmental considerations and a greater willingness of tribunals nowadays to consider the legitimate right of a state in managing its own environment. So for instance, we have a quote up here from Burlington and Ecuador, the case that Andrea looked at earlier. It states that proper environmental stewardship has assumed great importance in today's world. A state has wide latitude under international law to prescribe and adjust its environmental laws. This tribunal entered into the counterclaim phase of the proceeding, mindful of the fundamental imperatives of the protection of the environment in Ecuador. So we are seeing more and more of such statements by tribunals, basically emphasizing the importance of environmental protection and basically giving a bit more weight to the environmental considerations of states when it comes to assessing the claims as well as assessing the counterclaims in investment treaty arbitration. Another example we have here is Philip Morris in Uruguay, where the tribunal stated that investment tribunals should pay great deference to governmental judgments of national needs in matters such as the protection of public health, and presumably it would include issues such as environmental protection and standards. So if tribunals are increasingly more receptive, what sort of implications could one imagine from this new state of affairs? We think that it is possible for future tribunals to interpret environmental provisions broadly. As mentioned earlier, a lot of them are pretty vague, but if a tribunal is receptive to the idea of the importance of environmental protection and sympathetic to the state's measures, they could interpret the provisions in the treaties more broadly to encompass a wider set of environmental obligations. Secondly, we think it is possible for tribunals to interpret your human rights or your CSR provisions to include environmental compliance and protection. Thirdly, we think it's possible for tribunals to draw guidance from environmental provisions and norms when interpreting the treaty generally. And lastly, we think it's possible for them to rely on the Vienna Convention to integrate international environmental obligations. There are problems with each of these methods, obviously, and they will depend greatly on the specific wording in each treaty and instrument. But we think at least that those implications are increasingly likely and possible in future investment treaty arbitration. So that is, in a nutshell, the state of counterclaims in environmental counterclaims in investment treaty arbitration. We're happy to take any questions on this presentation, environmental counterclaims generally, or even things to do with our careers in different law firms. Thank you.
Thank you.
Thank you so much. That was really a great presentation, and it was highly informative because you have almost covered everything in a broad sphere. So moving on to the question first, an announcement is that if the audience has any questions, they can post in the chat box and we'll convey the same. So moving on to the questions from our side. In the past, that we have seen that there was implied provisions, and now we are moving to express provisions. Is it because of the ambiguity of the implied provisions and the will of the tribunal to interpret however they wanted, that we are seeing a shift from implied to express provisions of environmental counterclaim?
So I think that's a great question. I think Rajah touched on a very good point, which is that a few traditional treaty standards tend to be quite elastic and open to ambiguity and interpretation. I think a lot of the impetus when it comes to incorporating direct environmental provisions in treaties come actually just from global awareness of the climate crisis and a greater understanding and an acknowledgement globally that we all have to work hard to make sure that we protect our environment before it's too late. So I think it comes more from that. As I mentioned earlier, a few of the new environmental provisions are themselves also quite vague and do not really touch on the specifics, and we still await for those judgments and decisions to tell us what exactly those provisions might mean. So while they do go some way to making things a bit more concrete, I think there's still some to be asked for.
Right. So the second thing is it do we take this in a sense of counter strategy that some of the states use in employing a good defense?
Yes, so I think there are two things there. One is that the defense and counterclaim are two separate things. A defense is when a state raises something to block off the claim of the claimant. A counterclaim is a separate claim that once it raised, it's independent from the claim itself. So the counterclaim can survive and the counterclaim can still succeed even if the claim fails. So in a sense, there's a bit of a difference there. But secondly, yes, it's true that with counterclaims, we might be able to see in the future an investment treaty regime that's a bit more balanced and a bit more more bilateral than in the current often criticized way of being too unilateral and in favor of the investor. I think it is possible to see states taking a more offensive position in the future, but to be fair to the regime as well, it is created for a very specific purpose, which is to promote foreign investors and investments. So it is not surprising that there are so many investor standards in favor of an investor. And even in the new treaties that we see, it's not completely balanced either. They still retain a lot of the traditional treaty standards in favor of investors, and the kind of standards on investors against investors are fewer, and we just don't really know how it will play out and what real practical impact it would have on the quantum or the awards in future cases.
Right, sir.
Ma'am, this question is for you. Yeah, Kumar, go on.
Okay. So, yes, Andrea, ma'am, I was just going to direct this question to you. As we have seen that the treaties are often silent regarding the assertion of counterclaims that has the customary practice of investment arbitration tribunal. An arbitration tribunal provided any parameters for state asserted counterclaims. So, can you please highlight upon this particular point?
I'm sorry, could you repeat the last
Yes,
section of
surely,
it?
ma'am. Surely,
Was
ma'am.
it
Surely.
was it the perimeters that a tribunal provides for interpreting
It
treaties?
is about like as many treaties are often silent regarding the assertion of counterclaims and has the customary practice of investment arbitration tribunal. So my question is that has the customary practice for arbitration for investment arbitration tribunal provided any parameter for state asserted counterclaims?
Um, I'm not sure what exactly you mean by perimeters per se. Godwin, feel free to jump in whenever if you have a different interpretation from what
Yep.
I understand. But having run through the dispute resolution clauses that you're referring to in the treaties, I think it's pretty clear that traditionally, and this is not just limited to environmental counterclaims, but counterclaims more generally, that it will always be a point of contention as to whether a party can raise a counterclaim. So this isn't just limited to environmental issues, but say you want to raise a counterclaim on an infrastructure matter or any other regulatory issue against a private investor. The natural contention is whether the state even has a right to raise it. And this goes into a much broader question on counterclaims generally that we do go into detail in our paper. But sorry, am I missing your question?
No, in terms of if we are asking the question of what parameters are there in practice, it's not based on custom, at least for exit arbitration. In exit arbitration, in the convention itself, there are very clear conditions that are required in order for one to bring a counterclaim. For instance, it has to directly relate to the subject matter of the dispute. It has to have certain connection with the dispute, and that has always traditionally governed who can bring a counterclaim. And the only problem we face is that even the conditions in the exit convention have been interpreted differently by different tribunals, and therefore we end up in a situation where it is still better if you have a broad dispute resolution provision, and if you don't, there's always the risk that it wouldn't be accepted.
To add on, I think we can go to the slide with Article 46 of the Exit Convention. So most of the disputes as to whether counterclaims can be raised turns on whether a counterclaim falls within this article if there's no dispute resolution provision to turn to. So what it states here is that counterclaims must arise directly out of the subject matter of the dispute, must be within the scope of the consent of the parties, or otherwise be within the jurisdiction of the center. So these are three different points that parties tend to either argue on. So those are one of the issues, yeah.
Godwin, sir, just a follow-up question to this. directed to you, that can a state negotiator engage in an investment instrument that may change these tribunals constructed parameters or some guidelines that and make environment counterclaims a strategic reality for the states?
It is possible for the parties to agree separately. In Burlington and Poranco, the two cases, the parties did agree that counterclaims were acceptable, and therefore the tribunal did not spend much time going through the conditions. If you look at Article 46 itself, right from the first line, it does say except as the parties otherwise agree. So yes, party autonomy still plays a huge role when it comes to whether or not counterclaims are permissible.
Right, sir. Thank you. Arush, you can move forward with
Yes.
the question.
Sir, so can we believe that this is just a step taken for, like, when we consider the implied provisions that were put in place and the interpretation done by tribunal, this is a measure in order to protect the environment per se, and now many of the states are incorporating express provisions, but the, as you mentioned, the term environment is still ambiguous. Sir, if you can highlight more on this, because this is a really interesting point, that the term environment is so broad that how can an interpretation go in a circumstance like this?
Yep. So the typical treaty interpretation model can be found in the Vienna Convention on the Law of Treaties, and the starting point is the ordinary language of the term. And we like to say sometimes that it depends on which dictionary you pick up from your shelf to get the ordinary language. And then you look at things like the context of the treaty, the other provisions in the treaty, and you know, and based on that, I guess if a term, it's difficult to say because so much depends on the facts of the case and the circumstances of this particular treaty. So when we see treaties that are quite specific on having multiple chapters relating to the environment, I think that can lead a tribunal to think, therefore, that the contracting states had a huge priority placed on the environment and would interpret those provisions broadly. When it does not, then it becomes more iffy and more vague and questionable. I don't think anyone can kind of determine what environment would mean in the abstract per se. So it would have to depend very closely on the facts and the treaties itself.
Sir, just a follow-up question on this. We are taking a lot of measures in order to ensure environmental protection, but at the international level, we can see that the Paris Agreement, USA has pulled out of it. The Kyoto Protocol is not per se that effective. So what is the future of environment protection if we see it in that sense?
I think you're right that that we do face some hiccups in our international environmental agreements. That also leads us to the question on, you know, we mentioned earlier that Article 42 might allow you to apply international law and find environmental obligations within those law. But then with those kind of considerations, and also the fact that a lot of treaties impose obligations on states but not investors, it is very challenging without an express treaty provision to bring a claim based on international environmental obligation, whatever that means. If we can even come to an agreement on what that is. And it's true that there are those challenges, but with express treaty provisions, I think that's one way to counteract that problem. It's one way to say for sure that at least between two states, Morocco and Nigeria, or to us, at least between those two states and investors of those two states, we know for a fact that there is this thing called the treaty environmental obligation, and that, I think, is a step towards greater environmental protection.
Truly, sir, I believe
Right,
that in the sphere of international law, international environmental law, per se, there are more of soft laws than hard laws, and this is a
Yes,
great step in order to incorporate hard laws.
exactly. This is a reflection of the concretization of soft law into hard law, just one of the many ways that we're trying to do it these days, I think, in response to the climate crisis.
right, sir. So one more thing, that many in the exit tribunal in Abbasa versus Argentina was asked to consider counterclaims by Argentina, who alleged that the investor had failed to meet its investment obligations in respect of the water, that being an international law obligation. So, sir, can a claim be made on the premise of international law, and how far would it be successful?
Um, I think that is a great question. The Abbasa case, as you're aware, was slightly controversial in applying the Vienna Convention as well as other methods to incorporate some form of international obligations. The tribunal there also viewed that certain environmental provisions are more likely to be applicable to an investor than others. The reasoning there has been criticized by certain commentators to be too ambiguous, too vague, doesn't really tell us what's the next step. And I think that while it is in theory possible for us to find some sort of international environmental obligation, it has to be done very carefully. We have to look carefully at treaties that actually seek to implement obligations that can apply to investors. A separate question I would have for anyone seeking to take this path is, why is the state the best person to enforce such obligations? And is the investor the right recipient of those obligations? Because those treaties were not necessarily drafted or signed based on the intention of being used as obligations within counterclaims in investment treaty arbitration. So whenever you transplant a treaty or an agreement to another setting, you have to be very careful. And I think that those considerations were not fully dealt with in detail by the Abbasa case, and we would require future cases to really examine those a bit closer.
A question to Andrea, ma'am. Ma'am, many treaties, while not expressly permitting the assertion of counterclaims, do appear to envision them generally by excluding counterclaims in specific circumstances. So, what common provision in investment treaties and free trade agreements prohibit counterclaims in one very limited situation?
Sorry, the question is, what provisions prohibit counterclaims, prohibit parties from raising counterclaims? Is that?
Yes.
Is that? Well, thankfully we're on the Rosales slide as well. I think, while I wouldn't say this clause or this provision prohibits counterclaims per se, I think the question is more of whether counterclaims are accepted or not. So most of the time, tribunals would look at the subject matter of the counterclaim. So it wouldn't be a blanket ban on the fact that you cannot raise a counterclaim, but it might be the fact that you can raise a counterclaim in an infrastructural dispute, but you cannot raise a counterclaim on a water access or an environmental dispute. So it really depends on, first of all, what subject matter the investor has brought in arbitration against the state, and in response, what the state is answering with a counterclaim, if that makes sense. So that's why we've used the words narrow and broad instead of whether you can or cannot raise a counterclaim. So it's really subjective based on what's the thing in dispute.
Thank you, ma'am. Arush, we can move forward.
Yes, we'll just, audience, if you have any questions, you can write in the chat box. We'll just wait for the question and move on to the closing remarks.
Meanwhile, I believe we can have the closing remarks from the panelists. Till then,
Yeah.
the audience might write any question. Andrea, ma'am,
Yes.
followed by Andrea, ma'am, we can have Godwin, sir, to have the concluding remarks. And then we might move forward with the Q&A.
Okay. Well, I don't have any further concluding remarks other than that the questions were all very informative and they were very, very good questions. I do see some questions coming in though. How do issues of human rights and environmental law come into play in investment disputes? That's quite a good and broad question though. An example of environmental law coming into play in investment disputes is what we've been talking about today. For issues of human rights, I think we did kind of talk about it in our new generation treaty slide on how we've seen an increase of inclusion of human rights in certain treaties, but we also see people raising human rights. I can elaborate if he's more familiar on it, but it's a very similar concept of whether states can raise human rights counterclaims, and that's a whole different interesting issue in and of itself. Do you have anything to add, Godwin?
No, I think that's right. I think those issues they either come up in terms of questions of how a state has treated the investor. Sometimes investors do argue that, oh, the state has treated me in a particularly humiliating way or degrading way, and seek certain special damages from the states. Environment, like human rights questions also can come out in the future. We think in terms of like counterclaims and all that. I think Abbasa is one good example of where a human rights attempt will happen. And I think all these issues are now inevitable when it comes to investment treaty considerations. We have gone past the stage when, in the past at least, we try to keep investment law quite isolated from other fields of international law and considerations of environmental law or human rights. But these days, more and more of such considerations are treated as normal, appropriate to bring into the sphere of investment treaty disputes. Even like looking at simple things like just businesses and the way they carry out their investments, it's difficult to find places where the state doesn't care at all about your human rights or your environmental records these days. So I think it is inevitable, and they will definitely come in more and more in the future.
Okay, sir. We have
the
further
next
more
question
questions.
is, should UNCITRAL Working Group 3 give greater attention to the counterclaim as a reform option?
Well, I think our focus here has been on the ICSID convention, but it's true of a lot of arbitral rules and institutions that counterclaims have traditionally been recognized as something that was possible. None of these institutions really have a huge blanket prohibition against counterclaims per se. Especially with ICSID convention, it's literally in the convention that you can bring a counterclaim so long as you cover certain conditions. So I think it's more of a question of treaties doing their work and parties and lawyers actually submitting those claims.
There is one question: draft some articles so that people, environment, and investors get win-win situation. I believe this question is a little ambiguous. If you can rephrase, or if the panelists got the meaning of it, they can answer this.
I think it'd be great if you can provide us with some examples or samples of those provisions, and then we can bring it to the states to consider. But it is true that a lot of investors and states do view investment treaty as a zero-sum game in terms of either the investor win or the state wins. But if we can all work towards greater collaboration and in a win-win situation, then that would be the best. But I think the realities of politics and the realities of the economics just doesn't add up to that way.
Right, sir.
There is one last question about EIA 2020. I do not believe that this is the right platform to discuss EIA 2020. We can have a
Right.
separate session on that.
Put some other panelists. Thank you so much, sir. And it was a pleasure to hear
Thanks
from
for your
you.
discretion, Arush.
Thank you.
Thank you so much, sir. If you have any further concluding remarks to provide, sir, Godwin, sir, we can further move with it.
Yeah, well, thank you for having us. As I said, we are also available if you have any questions to do with practice rather than just environmental counterclaims, because ultimately we are both fairly new in our careers as well, and we've done arbitration seats, and we are practicing in different countries and all that. So we do have a bit of experience that we are happy to share as well.
We'll definitely have a session with that also, and we'll be more than happy. We'll be more than happy to have you again, Andrea Ma'am, Godwin sir, again with us, and all the students, all the professors who have joined us today. They'll be happy enough and privileged enough to hear from you again. So it was a privilege and our honor to have you guys on board. Thank you so much for joining us, ma'am. Thank you so much for joining us, sir.
Thank you.
Thank you, sir.
Thank you, sir.
Thank
So
you.
with this, we should call it a day.
Thanks everyone.